Normally on the last day, no mentioning are allowed.
At least
summer vacation will only get some material or when the last but
They were
maybe order may be passed on the taken up.
without the matter being listed. What is it?
Then it is listed.
We'll do it. Just remind us.
Multiple assessment.
Don't worry. We'll do it. We'll do it before rising. Don't worry.
Please.
So there is an option.
Oh, don't worry. We'll do it.
Pardon to mention your
Last day, no mention. Oh.
Your Lordship.
With my lord's kind permission, my lords.
Is it listed today?
Let's see, item 47 that your Lordship issued by the special magistrate.
My lord is approving, you can grant to liberty to move the vacation to.
Yes, that would have been.
If necessary.
Yes. Liberty to move before the first sitting of the court in the vacation. Yes, call the list.
Right. Judgment item number 1, WF 409 of 2025.
We have set aside the order and directed the government to take a decision to transfer that respondent number 3 to any other school, keeping in view of the seniority which is there. Hey. Black, where is the blue?
I agree.
Yes.
Item number 2.
No.
RBW PET 18 of 2025.
My brother. It was his parent judgment, so he should write a review judgment.
In the wake of the above, the review petition stands dismissed along with all the pending interlocutory applications even. However, in the circumstances, there shall be no order as to process.
Yes, I agree. Yes,
Item. Press admission item number 3.
Lordship, in this matter, if my Lordship's mental is concerned, that I have gone through Lordship, refer judgment, Lordship. Just I have only comparisons.
what?
Regarding maintainability of the writ application, Lordship, there is a private contract between the private parties with the writ is maintainable, not Lordship.
EBL International.
Lordship, I have taken Lordship. Three judgments, Lordship.
On a contractual field, the writ is maintainable, but there are certain checks and balances, nothing more than that.
Lordship,
that really goes to the merit of the case, whether it will come or not. Not a preliminary objection in that sense. It should be on a law point.
Lordship.
If you can show that in a contractual field, no writ lies, happy.
But
which I do not find.
You are the petitioner.
I am the petitioner, Lordship. Petition, Lordship, Because last time Lordship pointed 3 judgments. I have gone through 3 judgments.
I have come with that judgment.
Please, I have.
Welfare.
Yes, I have made that. I have made also comparison how my case is maintainable. That I'll try my best to convince your Lordship.
Oh, that is in relation to this private fora.
Lordship, yes. Lordship.
St. Mary's, and then Army.
St. Mary and
Army,
Army. I have gone through 3 judgments. I have also. Yes, I have made that.
But there is also ABL International Judgment.
Yes, Lordship. I have gone through all the 3 judgments.
And for the 7, he had contact with me, my lord, for man supply. I'm a bottling unit. That contact has been cancelled.
So that's please wait. It is my case. Lordship, the latest judgment, Lordship, that is.
Now the question is whether it involves a public law element.
Lordship, that only I can satisfy Lordship. If that involves, then my writ is maintainable, Lordship.
Because
Lordship,
there is a distinction which is drawn in those army. It says that so far as the educational system it may involve a public element. But when it comes vis-a-vis these employees, then it is under the private realm of law. It cannot go. So that distinction has to be drawn.
Lordship, kindly come to page 3. I have made that. Page 3, Lordship, of my recompilation. Page 3, I have done that, Lordship.
So we will hear out the matter.
I would copy it. Notice that how?
Yes.
Lordship, page 3, Lordship, a small comparison, Lordship, I made, Lordship. Lordship. That I have only army welfare education, but that Lordship. It is a clear case, Lordship, but I am not, Lordship. That's true, Lordship, I did contract. But Lordship, it is governed under state excise policy and Odisha Excise Act 2008, source followed by contract level regulation.
There also the education system that arise from Right to Education Act. It arises from many things.
But Lordship,
still the Supreme Court has made a distinction.
That distinction I have, Lordship.
If it is vis-a-vis the government,
Lordship,
relating to any education which impinges upon something, then definitely the writ lies. But
Lordship,
when it is a private contract between the two, then in that event.
But here, I claim discharging duty as per the statutory obligation. Their public law involves, Lordship, that is, it is.
We'll hear out the matter after vacation. Now it's the last day. We do not want
Lordship notice to go.
You're already, termination has already taken effect. Nothing more.
Yes.
No. How can it?
Termination.
No, termination, no, Lordship, no, Lordship. Still, Lordship, we are our work. No. How can you say no? Let them file an affidavit. If that is so, Lordship, let them file an affidavit. My statement can record.
They'll file an affidavit.
Lordship, but my statement, Lordship, we are working. Still, we are working, Lordship.
Till second day, we have engaged another.
No, they have not done, Lordship. I am working, Lordship. Lordship, can record my statement. If that is so, then it status quo may control, Lordship. If that is so, I am working, Lordship.
I am very much against the status quo order.
No, Lordship, only record my statement that I am working.
According to me, it's the most ambiguous order one can think of.
But Lordship, it is sometimes helps to
if you have a good case, straight order.
Yes.
Injunction. If do not, rejection. But status quo is so ambiguous that unscrupulous litigant will interpret in a different way.
But Lordship,
I can't status quo. Sorry.
I'm not on that, Lordship. Lordship, can you see only 2 documents, Lordship? Lordship, can you
seminal point involved in the instant writ petition, instant writ petition is whether the application under Article 226 of the Constitution of India is maintainable, straight, internable / entertainable. When the relationship between the warring litigant is governed by a contract coming under the realm of a private fora. the writ petitioner tried to, the counsel for the writ petitioner submits the notes of submissions on the maintainability of the instant writ petition, which is taken on record. The copy of the same is handed over to the should be handed over to the appearing counsels.
State I have already uploaded.
The appearing counsels.
I'm for the open.
Full stop. It is ardently submitted by the counsel for the writ petitioner that the contractual employees are still working as on date, and the alleged act of termination in the garb of the grounds and shown in the letter has not been implemented. Full stop. The aforesaid contention is refuted by the counsel appearing for
OP number 7.
OP number 7. So according to the said opposite party, after the termination of the contract, the engagement is done with the new incumbent who are discharging their duties
Since 2nd May.
since 2nd 2025.
Grateful, Lordship.
In view of such rival contentions having raised, we feel that it's a fit case where the notices is to be issued
Lordship.
and the affidavits are to be invited. We therefore direct the opposite parties to file their counter affidavit within 1 week from after the reopening of this court following the long vacation. All the actions which have been taken shall abide by the result of the writ.
Grateful, Lordship. Grateful. Lordship, it will come reopening.
1 week, they have given the 1 week after.
Reopening.
1 week after the reopening.
Sorry.
Given.
Item number 4.
Item 4, my lord.
It is really creative. You give me a hard
The
copy.
petitioners are small and marginalized farmers, my lords. They have filed this and marginal farmers.
Small and marginalized.
Marginal, sorry. Marginal farmers, my lord.
Okay.
And
I got
no, the balance.
marginalized. Then I just thought.
It's a marginal farmers, my lords.
Yes.
They have filed this writ application on the ground, my lords, that the Samruddha Krishak Yojana is not being made applicable to them, my lords, which provides for input assistance to all farmers, my lords. If your lordship kindly sees Annexure 1 at running page 15. This is the Samruddha Krishak Yojana. If your lordship turns
it is this Yojana is extended to a Krishak.
to a
So you
Krishak,
are a Krishak.
we are Krishak.
So-
Admittedly, we are farmers, my lords. There is a portal of the state government, my lords, whereby 67 lakh farmers have been registered. And we are amongst 50 lakh farmers who have already been registered, my lords. And 15 lakh farmers are getting this benefits and the rest 50 lakhs are not getting this benefit. Because, my lords, the government says if you bring the paddy for sale in the mandi, only then we will give you this input assistance.
Okay.
Which is against the very objective that the government.
Yes. Screen is gone. So, yes.
Which is against the very objective that the scheme proposes to achieve, my lords. Your lordships will kindly see.
Response to it.
I'll have to take instruction for this.
Take instruction and give a response.
Yes,
Let them give a response.
Certainly.
Thank
Well, by marginalized, I mean the state is marginalizing us. That's what I tried to convey, but it's obliged, well.
Yes. Affidavit. 1 week.
Item number 5.
This out still shop.
Right. What is this out still?
Yes.
Out still is a kind of shop located in some part of state of Odisha. Those who collect mahua flower.
Mahua flower. I know mahua.
Right. Mahua flower is collected. Then mahua flower is fermented. Then consequent upon fermentation, a liquor is prepared. It's country liquor, as good as country liquor. This is a kind of shop where they prepare it in the premises and sell it in the premises. That is called out still liquor. They have a still with them.
Actually, I am well aware of the word country liquor.
Country liquor. This is also part of country liquor. The same country liquor. Country liquor is produced from these sugar industries.
Molasses and
molasses,
and sometimes from the wheat as well.
Out of molasses, country liquor is produced. Here, out of mohua flour, country liquor is produced. The difference is country spirit produced through molasses. They sell it through different shops. It is prepared at one place, packed and sold through licenses. Here, licensee himself prepares and sells in the premises. This is the difference. Otherwise, end product is set. Am I clear, my lord?
No, I'm aware of two words where I used to appear. Don't worry.
So comfortable now I am.
Actually, this is called, the distinction is a cholai and pochai. There are two words which are used there.
Achha.
One is
Here also.
some kind of a molasses which contains some food grains,
right,
or there, and one from a raw spirit.
Pochai.
Here Kusuna chawla is used.
Usna chawla, mostly those grains are used for production of beer.
Kusuna chawla.
Usna chawla is pochai also.
Acha, pochai.
But I had an occasion to appear where the government decided to ban the cholai. And did not ban the pochai.
What is cholai?
That's from the molasses it is. I believe so.
Bihar and Odisha excise manual, they have pachwai.
Pochai is there. Pochai is there.
That is what.
Achha, my lord is saying that pochai.
Yes.
Yes, that should be true.
Yeah. I had an option and I argued as a counsel that if you Yes.
Item number 15.
Wait, please, man. Notes, we have come ready with the check, draft, my lords, 18 lakhs and 52,000. This is the draft, my learned friend. I'm handing over to him, my lord.
No, draft I can. Lord, here draft will not solve the purpose because he has to pay through the online as per the procedure, Lord. So
Very
that
well.
observation, Lord, see my.
Very well. I just have to encash this and pay it by file code.
The last date was 11/4/25.
That was.
Lord, see that extension, your Lord. Yes, your Lord. I'm not objecting, but
This just has to be encashed and draft is attached. Copy of the draft. I'm holding the original.
Yes. Extend time and then.
He has to
I just have to
deposit through
enter-
online as per the procedure.
Yes.
Lordship may grant me a week's time to do that.
What 2 weeks time? Get it cancelled and then transmit it. We are extending the time.
Well, great.
No difficult.
Great. Grateful. So obliged. Deeply.
Extended. Yes.
Grateful. Urgent copy of Lordship.
35 exercise. Registered 7.5. 7.5 tax pre-deposit. Section 85.
Clear for the next.
Item 16.
Petitioner challenging notification December 2023 by Central Board of India Customs. The petitioner challenging the notification number 56 dated 20 December 2023, the Central Board of Indirect Tax and Custom issued under 168A of the CGST Act and provide to extend the time limit of issue orders. And this is batch of distribution
168A.
168A.
Many cases.
It is a cover case only.
Lordship, my objection to that extent that interim order is there. Lordship, my blanket stay order may not be granted. Since the assessment order was passed on 18/4/2024, the petitioner has filed this petition after 1 year. So in that case, Lordship may not grant blanket stay order. Lordship, that is my limited. Lordship,
Lordship, the number of
let him pay the entire tax amount. So is bona fide.
Lordship, the number of
My Lord, in earlier, my Lord Justice Raman, while sitting with Justice Sarangi, my Lord has also passed that 100% so far as the belated filing of the appeal or writ petition, Lordship.
That is
no, this is the another case.
168A.
Lordship.
In 168, it is
When
separate.
you do not have the, suppose tomorrow that notification goes, you do not have the power to exercise under section 168 to extend that period of limitation without the sanction of the GST Council. Then
I'm
what
not.
would happen?
I'm not. Yes.
So
I am not objecting.
Then if you refund that money at that time,
Yes, sir.
what would be the rate of interest at which from the date of deposit you have to refund?
Why I am
So what would be the rate?
Lordship, why I am saying.
Will you refund it at 12%? We will pass that order from the date of deposit.
Lordship, that
This
is why I am. Lordship, for a moment. Lordship, for a moment, 1 minute, Lordship. This is the second sub-item.
Normally in various matter, that order is passed. Without prejudice, you deposit. In case it is held to be ultra-vires, then you have to refund the money from the date of the till actual disbursal at the rate of 12% or 18%, whatever. So statutory interest will not apply there.
Lordship, why I am.
Are you sure? Have you taken that in?
For a moment, Lordship, otherwise I am submitting, Lordship, otherwise I am submitting. So far as the second sub-item is concerned, I have the information that this petition, certain operational creditors have filed the IBC application before the NCLT Hyderabad. Till date, no CRP has been admitted. Once the petitioner entered into the CRP, we cannot toss the petitioner, Lordship.
You can claim there. You
Lordship,
have to approach that forum.
Lordship, to secure the revenue, Lordship.
Sir,
in 16-2 cases, your Lordship is directly 20%, Lordship.
In how many cases department is to be tested?
It is 2.
It is I am leaving your Lordship. In 16-2 cases, your Lordship is directing 20%, Lordship.
Okay, for the next.
Same.
Both the cases. Item 17.
Lordship, we are challenging ex parte order passed by the opposite party number 1, where they have passed in order without giving us opportunity of hearing. And Lordships, they have the adjudicating authority has already dropped the opportunity against us, but they have not taken into the consideration also. Your Lordship, there is an order passed by the court which have covered this matter.
If your lordship will remember, this is with regard to the non-speaking order, your lordship. I cannot develop it more than the last impugned order. Because it is all the wordings are also same, you know.
The same of sir.
Same appellate authority. I cannot develop it more.
Yes.
Anything.
Item 18.
May I please, your lordships? May I please, your lordships? Lordships,
I am going just immediately. Go. Was falling his love.
18.
Lords, less than 7 days, your lordship.
17, 18. Assessment year 17, 18.
Yes, my lords. Assessment year 17. Less than 7 days.
Yes.
Lordship, sub item same, lords.
So both the pieces. Item 19.
19 lords same, lords.
On the last day, you are taxing me.
Yes.
Item number 20.
You are not taxed. I am taxed.
Yes.
Item 20, my lords, I am being led by Mr. Sridharan.
Wait, please, your lordship.
He's.
I don't want to tax your lordship on the last day. I didn't know that.
Yes, that's true.
Lordship keeps it on vacation. That's
Okay.
submission
After-
is a lot. I hope they won't attach my bank account, etc. Lords, that's it.
No
Lordship.
difficulty. Come after vacation. We don't move.
Let them not take any precipitate action. It's covered by a division bench judgment of your lordships.
If Mr. Mishra is here, we'll take.
If he tells his officer, that is enough, your lordship.
Next.
Item 21. Okay.
Please, Lordship. Lordship, this matter relating to RC cancellations.
More. Deposit. Yes. Cancellation, same order.
So there is Satyajit.
Right.
Yes. Call the name.
Item 22.
Very pleased, in this matter, though I have so many issues, but today I am pressing only one issue, that is during pendency of the appeal, when I have deposited the pre-deposit amount, the attachment has not been vacated. That is violating 107 subsection 7 of the articles.
Yes.
Your lordship,
Belatedly. But
belatedly. And I have to take instruction whether in the meantime that appeal has been disposed of, because on one day the appeal is to be because in so far as the delay is concerned, it is admitted delay, your lordship, because he cannot claim that it is not within the notice.
See, if the deposit has already been made and appeal
Already
has been disposed of, then the attachment will not.
Your lordship, if not disposed of, I will do.
But during pendency of appeal also, that attachment needs to be vacated.
Take instruction. We are directing this matter to be listed immediately in the vacation. Don't worry.
Mal.
Oh, bless.
Vacation plan.
Item.
We will, Mr. Mishra, take instruction.
Your lordship, in the second vacation, in the first week I will be. In the first week.
Sir, you are not the only panel counsel, sir. He is there and other persons.
As your lordship.
Item 23.
Yes, you need not be. They must also get the chance.
Your lordship, I am always.
Yes.
My lord, in absence of the GST tribunal, that 10%.
Yeah.
Grateful, man.
Item 24.
Item 24, may it please your lordships. Lordships, I am here for non-disposal of Annexure 5. That is my application for rectification of orders. There has been some arithmetical error. Lordships, if Lordship sees the...
Take a decision, either reject or allow, whatever. Take a decision.
Let's say give a
whether maintainable, not maintainable, at least the decision must be communicated to him.
Lordships, the order in original is very clear. It has asked for
whatever they
yes, your Lordship.
dispose of the
They'll have to dispose of your Lordship.
Lordship give a direction to take the representation.
Your Lordships, what is
yes, this is already there. They have taken out Annexure 5. You take a decision on Annexure 5. Whether it is maintainable, not maintainable, whatever, communicate to him.
Lordship.
The instant writ petition is taken out, has taken out primarily on the ground of inaction on the part of the additional commissioner.
Yes, your Lordship. So P1
and the Central Excise Commissionerate, Rourkela, in not disposing of the application for rectification taken out on
Annexure 5, your Lordship.
11/4/2025.
11/4/2025.
24.
Mr. Kedia, the learned Junior Standing Council, the learned Junior Standing Council submits that in absence of any instruction, he is unable to disclose whether the application has already been disposed of or not. Once the SSC has moved the competent authority with an application for rectification of an order dated
12/4/2025, your Lordships.
12/4.
12/4.
12/4/2025, it is expected by the said authority to take a decision thereupon. We therefore dispose of the writ petition directing the commissioner, what is this, additional commissioner, GST and Central Excise Commissionerate, Rourkela, to take a decision on the said application for rectification filed by the petitioner and dispose of the same within 4 weeks from the date of the communication of this order, if necessary, after affording an opportunity of hearing.
Lordships, may I pray something?
For abundant precaution, next paragraph, we hereby made it clear that no opposition to go into the merit or the demerit of the said application for rectification filed by the petitioner, and it is open to the authority to take an independent decision by recording proper reasons in accordance with it.
Lordships, may I pray something? Lordships, my for appeal under section 107, the limitation of 161 and 107 runs concurrently. So I'm missing out on my limitation under.
That is your baby. You have to take a decision. We can't make anything on that. Simply,
Lordship, my limitation goes.
Let them dispose of within a time frame.
Then my lords, my limitation under 161 goes.
Oh, I do not know. If they rectify your order, then it revives your limitation. Then why you are?
Oblige your Lordship.
Item 25.
Yes.
Item 25.
Cancellation.
Cancellation.
Next. Item number 26.
Made, please, Manoj. Manoj, I appear for the petitioner, Manoj. Manoj, the petitioner here, Manoj, is a manufacturer of electronic scooters, Manoj. There's a Government of India policy, Manoj, that there will be a tax concession on these scooters. Manoj, because of this, Manoj, when I pay Manoj tax on these scooters, Manoj, the tax rate is 5%. When I'm buying the inputs, Manoj, the tax rate is 18 and 28%. Therefore, Manoj, I come in what is known as an inverted duty structure. Manoj, if there is an excess credit, I am entitled to a refund. Manoj, 8 different states have given me a refund, Manoj. In Odisha, Manoj, a view has been taken basis a circular that if your input and output item is the same, which is scooter, because Manoj, over here, what I do is I stock transfer the scooter, Manoj, from Chennai. It comes, Manoj, to Odisha, and then I sell it. They say, then we'll not give you. Manoj, that circular itself has been read down, Manoj, by multiple high courts, Manoj. Manoj, all I'm requesting is, Manoj, that circular cannot be the basis for denial, Manoj. And Manoj, factually, Manoj, I'm buying inputs which are at a higher rate, and I'm selling scooters at 5%.
You want to hear that?
Your Lordship, it is already Honorable Supreme Court has decided the matter. Not only basing on the circular, this has been, Your Lordship may kindly turn to the impugned order.
Then we need to decide.
After Honorable Supreme Court judgment, I think.
Then also, once the litigant has approached to the then it is a duty of the court to decide it.
Your Lordship.
Either accepting his contention or rejecting his contention.
Your Lordship. And it is appealable, Your Lordship. It is appealable.
Clause B is not appealable. Prayer clause B.
Your Lordship.
Prayer B is not appealable.
Your Lordship.
So,
the notification.
So, that is, you file your affidavit within 1 week after the vacation. You decide it. 1 week after vacation, you started to appear. Yes.
Item 27.
Grateful, my lords.
validity of
All points, including the
being challenged. Sri M.S.RAMAN, six accommodation, 4 weeks accommodation to 5 counter affidavit. After vacation, 1 week after vacation.
Yes,
Yeah, let's gratefully.
Yes.
Item 27.
It's a case of cancellation of registration certificate, and that is covered by your Lordship and
Item 28.
28 on in absence of the GST tribe. 10%. Yes.
Item 29.
my plea by last.
Yes, I will pray your Lordship will kindly to turn to page 45 of the brief finance. Page 45. This is GSTR 2A. This carries reflection of the input tax credit available on the value of supplies bills. So let me kindly see the amount invoice value, total invoice value 20,27,163. And just a side of it also kindly see total taxable value 17 crores 17,90,563. And this is the tax component. So what has happened? The supplier has made mistake bills. Instead of 17 lakhs, he made page 44, just the previous page. Let's rectify the mistake bills. That your Lordship will find GSTR 9, the invoice value 20,27,163, taxable value 17,17,935. My Lords got it, right? So this is the rectification. He got it rectified while filing GSTR 9 bills. Now, because what happened, the wrong figure which he has uploaded, because that was treated by the income tax department as if that is my value of supplies. Your Lordship will find they made assessment at page 23 bills, summary of information, page 23 bills. The income tax authority while assessing bills, as per information, I am reading placing bill.
Yes, what do you say?
My Lord, kindly see the prayer of the petition, my Lord.
You have filed appeal bills. Yes. Now they have attached bill, right? I have agreed by attachment bills. That is all.
My Lord, appeal is pending, my Lord. In the pendency of the appeal, the petition filed.
The prayer appeal be expedited and recovery may kindly, because it particularly under this special background. Humble prayer, this is only.
First prayer, I think, very innocuous. The second prayer is very dangerous.
Mine. Well, they have asked to pay the 20% as a prerequisite.
Of what?
The guideline issued by the CBD.
One numerical figure has created a mess. I think two numerical figures, 2 zeros.
Correct.
In Mr. Kaura's case, one day, auto rickshaw was 3 crores. You were doing that case.
It was a human error.
That was also in the under GST.
Yes.
And the total invoice value is 20 lakhs. How can it go to
20 crores?
17 crores? I can understand the excise when the excise duty is 400 times or 500 times. I can understand. But that too. And the rectification has come.
Let them pay the 20%.
That the invoice value, you have not disputed the invoice value is not 20 lakhs.
Except for that, will be automatically.
It's a human error. You can't do it. Sometimes it so happened.
And LG Electronics, your lordship, have seen Honorable Supreme Court said 20% is not a fetter at all because it's a.
Oh.
That is also not a fetter.
This is
income tax. Income tax. Yes, ma'am. Yes, ma'am.
In that particular amount and assessed that this is your loss.
Let them expedite hearing, brothers, and I will be protected only in the meantime. I am the sufferer. Mistake is committed by them. And also the rectification is done before assessment. That GSTR 9, that the supplier has already rectified prior to assessment.
What do you say? But we have taken a decision that those should not, when disposing of the pending.
Right.
And will put that pendency of the writ petition shall not stand in the way of deciding the appeal. Because we are stuck up with our own order. I have dictated, my brother, we both dictated that it is not permissible that writ petition is disposed of without entering into the facts and then protection is given till you approach. Supreme Court has also deprecated. So we have to keep this alive.
My lord.
Appellate authority has not passed any interim protection.
No, my lord.
Oh, that assessing authority has to.
Assessing authority.
Now, under GST?
Under GST, auto stay, your lordship knows.
No, there is no assessment taken up. For this
GST,
period.
GST, I do, because there's a supplier, I don't know what happened to him. Supplier, but now there is attachment, Annex 6. That's the difficulty. My bank account is attached.
We will lift this attachment till you get the instruction.
Till
the next day.
We'll take this.
And during this period, if you dispose of the appeal, well and good.
That also you disclose to us.
Fine.
No difficulty. Yes.
It is unbridled. You can dispose of the appeal in the meantime. Then tell us.
Fine.
This is a fact. Apparent fact. 17 crores has been rectified as 17 lakhs. So you have not taken that into consideration.
Yes. But matter to appear 2 weeks after.
Please,
First week.
Yes.
3rd July. 3rd July.
Yes.
Item 30.
Population.
May I please, your lordship. Item 30 is a GST covered order manner for multiple assessment year, single SOCOS notice was issued. The GST covered.
Yes.
CGST or CGST.
Corrected copies.
Corrected copies.
You are standing counsel?
Junior standing.
Junior standing counsel, CGST.
Yeah, 31.
You are also
31. I am in 31, your lordship.
In 30 you are.
Yes.
Item 32.
32 minutes regarding GST RC cancellation.
Yes.
Item 33.
Lordships, this is covered, show cause notice.
Okay. That's what the other side. 33.
Mr. Kedia.
Union of India.
Yes.
Please call Mr. Kedia.
Mr. Mahanti is income tax. You are there? Yes. Come.
Yes.
You can appear for GST. GST authority.
Yes, central
GST. Mr. Rajesh Singh for opposite party number 234. Department of Revenue, you are not appearing. You are also.
No, Union of India. Mr. Bade.
234. You copy, give copy. No, writ petition copy have you served?
Yes, Your Lordship, that's all.
Extra copy.
On GST Standing Council have you served?
Yes, Your Lordship, I am serving one extra copy. One copy I have already served, Your Lordship.
You served to Union of India, not Central Research.
You must have served on Mr. Council. You must have served on opposite party number 1.
One only.
You must not have served on 2, 3, 4. Have you served?
Lordships,
whom?
Mr. Kedia.
Kedia. Where is he? Anyway,
same. It is almost all the same.
Copy of petition is served on Mr. Rajesh Singh.
I'll file my memo appearance.
Yes.
Item 34.
Maybe give three have been now on the last day. Go immediately redo it.
Sorry,
Yes, sir.
Yes, my lord. Petitioner is appointed as a non-formal instructor, my lord. Having put in 9 years of service, this scheme was abolished. Then there the village committee was empowered to recruit only the experienced persons. They have not done it so.
Because it appears you'll have to file counter.
Yes, my lord.
Let them file counter. Yes. Nice. And move, you did not move in a right direction. You moved in a reverse direction.
Right.
You moved from a post to pillar, not from pillar to post. Yes, counter, 1 week after.
Item 35.
This is the board document doesn't have the compliance report. Since admitted in the order of it been brought over as one of secret.
Yes.
35.
Second time to take instruction regarding payment of pension. The order itself violates Rule 7, my lord.
What?
Order of punishment in a department of proceeding, directing withholding of 5% pension. That order was passed under Rule 7 of the pension rule. Rule 7 is not applicable to me. They have taken time earlier, my lord, to
come after vacation. Take it from Yes.
Future debt matter.
Item 36.
May please your lordship. That's the petitioners in writ application file one writ application challenging two different orders passed by the same authority on two different dates. So, Honorable Court, we raise objection. You are directed to file another application, but with the same prayer, again, another writ application was filed. However, the Honorable Single Judge were pleased to confine both the writ applications to each, even though the prayer was not amended. But in the present case, even though for the same property in 2004, a suit was filed, it was dismissed for default, no attempt was made to restore it. Revision was filed. In 2013, a revision order was passed. Challenging that, in 2014, another suit has been filed, which is pending before the civil authorities, and challenging that 2013 or 2018 writ application.
Where is the notice to the other side?
State and private parties are also the notices to go to them.
Notice 3 weeks. Notice 3 weeks.
Yes, sir. The Honorable Single Judge directed to consider and dispose of within 3 months.
It will abide. Don't worry. This
stay for the direct notice in IA also.
Yes, notice.
Yeah.
Notice in both.
Item 30.
One has to go to notice.
All private respondents are there.
No, 1, 2, and 3. I will take serve copies extras, and so far as 4 to 9 are concerned, I will take.
Not 1, 2, 3.
Yes, Lord.
2, 3 separate. Adequate numbers. But you have to private private respondents.
One thing may I pray,
Yes.
One thing, this may be taken up along with another writ of 853. That may be on that day.
That let it appear after the vacation.
Yes.
We will tag it. Without looking at it, no.
Grateful.
Call.
Item 37.
I plead. Well, writ appeal is directed against the judgment of the Honorable Single Judge arising out of a no confidence motion of a Panchayat Samiti.
Sarpanch.
No, it is Panchayat Samiti member and chairman. That is, and I have prepared a very short date chart. Of course, it's a pure question of law. In fact, it's a elected Panchayat Samiti. On 28/3/2025, under Annexure 1, I have also made the translation. The respondent number 2 issued a notice to the member of the Panchayat Samiti intimating therein that a special meeting will be convened for no confidence motion on 5/4 and on 5/4/2025. That is at Annexure 1. Then 30/3/2025, appellant number 14 is the chairman, made a grievance before the collector and district magistrate Kedrapada regarding the fabrication of the signatures of some signatories. Then on 4/4/2025, appellant number 14 addressed a letter to the respondent number 1, apprehending the failure, respondent was the collector, apprehending the failure of no confidence motion, and to prevent that, the district administration is planning to defer the date of meeting in violation of the Panchayat Samiti Act and rules. And on the very same day, that is on 4/4/2025, the respondent number 2 had later dated 4/4/2005 postponed the meeting scheduled to be held on 5/4/2025 against the appellant number 14 vis-a-vis the no confidence motion, citing health problem of 9 members of the Panchayat Samiti. Even there is no letter, nothing amongst the signatures of 9 members were not also there. Only ground is that the health condition of 9 member of the Panchayat Samiti. That is the only ground. And that was the date of deference. You also look to the provisions of the rules. The Orissa Panchayat Samiti Act, section 46B. 46B says that procedure for no confidence motion, the Orissa Panchayat Samiti Act. I'm just reading 46B. Vote of no confidence against chairman and vice chairman. Here is the chairman. Where at a meeting, Samiti specially convened in that behalf, a resolution is passed, supported by a majority not less than 2/3 of the total number of members, having a right to vote, recording want of confidence in the chairman or vice chairman of such committee, the resolution shall forthwith be published by such authority and in such manner as may be prescribed, and with effect on the date of such publication, the chairman or vice chairman, as the case may be, shall be deemed to have vacated the office. Then 2, we are concerned with 2. In convening a meeting under subsection 1 and in the conduct of the business at such meeting, the procedure herein specified shall be followed, namely, A, no such meeting shall be convened except on requisition signed by at least 1/3 of the members with a right to vote, along with a copy of the resolution proposed to be moved at the meeting. Then you also come to F. F has been interpreted by the Honorable Single Judge. No such meeting shall stand adjourned to a subsequent date, and no item of business other than the resolution for recording want of confidence in the chairman or the vice chairman shall be taken up for consideration at the meeting. Then you also kindly come to G. If the number of members present at the meeting is less than a majority of 2/3 of members having a right to vote, the resolution shall stand annulled. Then kindly come to 3. Where a meeting has been held in pursuant to subsection 2 for recording want of confidence in the chairman or vice chairman, as the case may be, no fresh requisition for a meeting shall be maintainable. A, in cases falling under clause G and H of the said subsection, or where the resolution is defeated after being considered at a meeting so held before expiry of 1 year from the date of such meeting. That means for 1 year there cannot be any further meeting. So now the F, if you also look to F and G, now on that it was fixed to fixed, but on 4th, on the plea that 9 members, on the ground of health of 9 members, which has not, that was specifically raised before the Honorable Single Judge, but the Honorable Single Judge has avoided that particular issue, saying that that is a disputed question of fact, but no counter has been filed by the state, no counter has been filed by the disputing the, so far the pleading of my pleading, that on 4th itself, we have brought it to notice of the collector that this has been deliberately done to somehow defeat this F, and therefore my case will come under G. That will be annulled. That is why on 4th itself, they say that 9 members have, on the ground of illness of the 9 members at a time. So therefore, you have to look to that, that is annexure 4 at page 16 ODI. I have made the translation. If you also look to that, page 4. This was the subject matter of challenge. And page 4, annexure 4, that is at page 4 of the translation that bunch. Office of the Sub-Collector on 4/4/2025. The no confidence motion was fixed to 5th/4. But on 4/4/25, 2 members of Panchayat Samiti, Sarpanch Mahakalpada Panchayat Samiti, regarding the postponement of the meeting of no confidence against the chairman, Mahakalpada Panchayat Samiti, Srimati Kalpana Rao. Sir, madam, it is information to all members of the Panchayat Samiti that it was decided to hold special meeting for no confidence against the chairman, Mahakalpada Panchayat Samiti, on 5/4/2025 at 11 AM in the meeting hall of Mahakalpada Panchayat Samiti, but 9 members have requested for postponement of meeting because of their absence, showing health ground. This is the reason. The reason has shown that this is the only reason, which I have specifically said in my writ application, that they have deliberately done this to somehow nullify the no confidence motion to be held on 5th April 2025. Then, if you also look to G, then had it been taken place, the meeting would have been held on that date, on 5/4, then obviously I could have taken the benefit of G. And if you also look to the judgment of the Honorable Single Judge,
you are a person,
we are 22%. We are 22%, including the chair members,
who are against the motion.
Your Lordship, we are appearing for the opposite parties, Your Lordship. We are also the members of the Panchayat Samiti. I am filing it for 12 numbers of persons, Your Lordship.
Sir, I have instruction to appear for the 27 of the opposite party, my lord. I have the instruction to appear for 27 of the opposite parties who are the members, my lord, who have brought the no confidence motion.
In fact, Your Lordship, the requisition
is a number game now. You are 22, they are 27,
the whole
and they are
12.
That is exactly the point before your lordships. Total 64. Total 64.
Out of 64, 41 have moved requisition.
That is correct.
They
So far as
satisfy the
requisition is
requirement,
concerned, but my respect to submission of your lordship, subject to your lordship. If annexure 4, the region which was assigned, 9 members were absent. The 9 members were on the health ground, they're absent. So had the meeting took place on that date on 4th itself, then I would have taken the benefit of G. It was nullified.
And the moratorium period of 1 year.
Yes, sir. Yes. Yes.
In fact, your
That
lordship.
is exactly the point.
That's it. You're the confused.
And the Honorable Single Judge has not considered this aspect at all in the judgment. The judgment has proceeded as if that so far as the provision is concerned, they have the power. Collector has the power.
But the rule speaks about adjournment. There shall not be adjournment. But on the date fixed, 1 day prior to the date fixed, the meeting was deferred. My lord, adjournment and defer, that has been considered by the division bench of this honorable court in a judgment, my lord, if my lord should have a glance to this judgment. And they have interpreted the perimetria provision. If your lordship may kindly have a glance. Para 5 of that judgment. They have interpreted the similar provisions.
My point is that even accepting that argument, that judgment, and accepting that adjournment, but the ground on which it has been adjourned.
Your lordship may kindly see. 5.
This is my question.
Para 5, your lordship may kindly see. The moot point involved in this case, therefore, is also whether the meeting held on so and so in which the vote of no confidence was passed against the petitioner is an adjourned meeting as contemplated under section 24(2)(h) of the Act, and as to whether such a meeting barred by the said provision or is contrary to the said provision of so and so. For better appreciation, 24(2)(h) of the Act is quoted hereunder. If I may take your lordships to 24(h), your lordship may kindly see the same perimetria provision. No such meeting shall stand adjourned to the subsequent date and no item of business other than the resolution. Now, my lord may kindly come to 6. A reading of the above provision clearly shows that no meeting for considering a vote of no confidence under section 24 of the Act can be adjourned to a subsequent date. Learned additional government advocate submitted that the meeting having not been held on so and so, the question of adjourning the meeting did not arise. And as a matter of fact, the meeting scheduled to be held on so and so having not been able to be held due to exigency, which is a case here, my lord, beyond the control of the sub-collector. The action of the sub-collector in issuing the notice to hold the meeting on so and so is neither illegal nor contrary to the above provision of the Act. Now 8. Neither the word adjournment nor the word deferred has been defined in the Act and the rules framed thereunder. The word adjournment, according to Black's Law Dictionary, means putting off or postponing of business or of a session until another time or place. The act of the court, legislative body, public meeting or officer by which the session or the assembly is dissolved, either temporarily or finally, and the business in hand dismissed for consideration, either definitely or for an interval. If the adjournment is final, it is said to be sine die. According to the said dictionary, the word defer means delay, put off, remand, postpone to a future time. According to the concise Oxford Dictionary, the word adjourn means break off with the intention of resuming it later, and the word defer means put off to the later time postmortem. Then, your lordship, 10. In common parlance also, we are of the opinion that there is certain difference between an adjournment and a deferment. Adjournment always means any proceeding taken up and is shifted to a future date. But deferring a proceeding to a future date is on account of inability to hold the proceeding meeting on the scheduled date. It is also clear from the above provision of the Act that bar imposed under section 24(2)(h), here it is 46.
It's an adjournment.
It's an adjournment.
Not deferment.
Not deferment.
The meeting was not held, your lord, before the date.
That is the day before. Sir.
Yes.
That is an admitted.
That is a day before.
No.
That is my case,
Yes.
sir. My case is, sir,
that there was no justification
Yes, sir.
either in deferment or in adjournment.
Yes.
Whichever the word you use it. There was no
So
justification.
excluding 9%, they could have
And
done.
if you acted with malice, with an intent, so that the advantage of the law cannot be taken by them, then in that event he has come up before the court that where was the occasion for 9? Who were the 9?
Yes.
And who have applied? Who have communicated that my illness? Nothing.
No,
If you do not spell out, even you make a deferment, but with an intent to frustrate, then that comes.
Your Lordship, first of all, Your Lordship, with regard to section.
This is what is
Yes, sir.
sum and substance of the entire.
Your Lordship, my
stand.
humble submission is that 46BA, Your Lordship, talks about the requisition, which is the requirement is that the 1/3 of the requisition must be made.
No,
Your
sir.
Lordship.
There are two aspects of
Yes.
the matter. There are two aspects of the matter. There is no difficulty because the law requires at least 1/3 of the total members.
Yes, sir.
They must make a requisition.
Yes, sir.
And if the requisition is made, then there will be a date fixed for the purpose of this no confidence.
Yes, sir.
And if it is passed with a majority of 2/3, then in that event,
Yes, sir.
he will be impeached, he will go out.
Yes, sir.
And then the law put a fetter that you will not adjourn
Yes, sir.
the meeting.
Yes, sir.
The object is that adjournment after sensing that I will be defeated, which is a very common now in our parlance as well. When a bench put a difficult question in the midst of an argument, then the adjournment is sought.
Yes, Your Honor.
By a member of the bar.
Yes.
Immediately, the adjournment is sought. So this is what an
Your
adjournment is
Lordship, in
sought.
fact,
Then you are taking advantage. That adjournment when the meeting commenced. And I understood.
Yes, sir.
And in the midst of it, it is adjourned.
Yes.
Deferment is something where it never commenced. It can be done.
I bow down.
That is what is the judgment he says.
Yes, sir.
He says that even a deferment is tainted with a malice. Then in that event, also the court should step in. Because you knew that you will not be able to secure 2/3 majority on the day when the meeting would be held. And then you deferred it.
Lordship, my humble submission is that.
And there was no material before you.
Absolutely.
Show us that who communicated, how many communicated, name, what was their difficulty. Nothing of that kind was communicated. If I understood.
Yes,
then
sir.
argument is
Yes, sir.
So you can say I'm a good.
Yes, sir. And that those 9 members could have been excluded and meeting could have been held also.
Lordship, my humble submission is that a copy be served on us.
Yes,
If I
sir.
take it up 2 p.m., Your Lordship, we'll come with an answer, Your Lordship. With regard to Your Lordship's query.
Yeah.
Yes, I'm giving a copy.
Yes.
Give a copy to them. The question is of a motive, nothing more than that.
Sir.
If it is deferred with the ill motive, then.
So far the judgment of so far the judgment of the honorable single judge also kindly see.
No, I don't think so.
The next date is fixed.
21st is the
21st is the
21st is the date.
They have stalled the no confidence motion once.
On the 18th.
19. Okay, my lord. When the 19th, the no confidence motion was
There is no question of further deferment. It does not come under the adjournment.
That
Serve
was
a
the
copy,
argument
come at
people are
2.
single judge.
Come at 2.
Yes,
Let us see.
let us subcopy. Let you take it out to 30 p.m. Let them sub a copy.
Two.
That's it's 1.
2 o'clock.
30 now. They've not sub copy. Now, my lord. At least we need half an hour.
I'm making Xerox and giving.
They're doing Xerox, my lord.
Photocopies, your lordship. That's why.
It will taken at least 50 half an hour, my lord, to go through it. Because this is the
entire thing you did not lodge a caveat. You did not. Anyhow, since you have appeared, we are giving you an opportunity. Now you cannot dictate that when to be taken up.
Not at all, my lord.
You are at 4. So anyhow, we respected your appearance. Come at 2.
Yes, sir.
Go through it.
No. Serve the copy as well. I've served the copy.
Yes.
My lord, here, my lord, 1/3 majority is required to move the requisition and 2/3 for the floor test. Now the requisition at no point of time has been questioned by anyone, my lord. So far as requisition, nobody.
But it's the deferment which is questioned. Now
My lord,
tell us
even
whether there was any document received from these 9 members showing their inability or something of that kind.
My lord, I have a submission, my lord. But suppose this deferment, let us say there is a motive motive attached to this deferment. That may be a ill motive. I'm going to an extreme extent, but it is a case which I'm arguing only to the extent saying that it is just a submission, my lord. It is not an acceptance, but it is a just submission, my lord. For some reason, X, Y, Z reason or motive, whatever, there is a deferment. It is not a case of adjournment. Now, once there is a deferment, there is a fresh notice for floor test. So, what prevents them from appearing before the floor test and prove their majority? If at all they prove their majority, there is no dispute.
Very simple way of putting a thing. But the motive is the hindsight of it. One has to honor. And this is the lifting of a veil behind.
May I answer, my
lord? Your lordship.
So one has to lift the veil.
Your lordship, to answer your lordship's query, the answer lies in the annexure itself, your lordship. Since the translation was made from Odia to English, yes, your lordship.
Correspondences exchanged by these 9 peoples.
Annexure 4, your lordship, page number 60. In fact,
show us the correspondences made by these 9 peoples, communicating that we are suffering, we can't attend.
Lordship,
show us, no problem. We don't. I will close.
Lordship,
here and now. Show us.
Lordships,
show us that they have communicated.
May I answer, my lord? Lordship, may I answer?
Yes, sure.
Lordship, page 60, my lord. Page 60 of the paper book.
Fine. Yes.
Lordship, it's not in dispute that the sub-collector is the authority under 46B to call for the meeting, to verify the documents, and to see whether the requisition satisfy the
no doubt. Nobody is putting any doubts on the competence. The only thing is the decision to defer.
Yes, ma'am. I'm saying
which is distinct from adjournment. Show us was necessitated or
Page 60,
corroborated by any document.
Page 60, my lord.
Sure.
Page 60.
My lord, by kindly, yes, page 60.
Last line of the
There was some confusion with regard to the translation, Your Lordship. Lordship may come to.
Milord, may I intervene, Milord, in this case? If your Lordship would permit me, I may come to the court. Just now I raised.
Yes, please. Please come.
Milord, may I come to the court that way?
Please come.
Milord, I am come.
Yes, show us. Where is the document?
First, Lordship, I'm writing in Odia, reading in Odia, my lord, then I'll read the translation.
No,
copy.
you can. If you read in Odia slowly.
Yes, master. I'm trying, my lord.
Yes.
Last thing, my lord. Matra, ethire, 9 ଜଣ ସଭ୍ୟ ସଭ୍ୟା ସ୍ୱାସ୍ଥ୍ୟଗତ ସମସ୍ୟା ଦର୍ଶାଇ ଅନୁପସ୍ଥିତ ରହିବା ଓ ଉକ୍ତ ବୈଠକକୁ ସ୍ଥଗିତ ରଖିବା ନିମନ୍ତେ ଆବେଦନ କରିଛନ୍ତି.
Where is that avedana? Show us the avedana, no problem. Dorshaiya, no problem. Show us the avedana and where Dorshaiya, show us where he has shown and where he has made an avedana. That's all, nothing more than that. Matter ends here. Sir, there is no quarrel to this.
The sub-collector was satisfied, it was applied, not requested.
When you say that the Swastogato Dorshaiya Avidan Koriasen, then you show that this is what is there.
But that has to be
some application, some communication. So,
but that has to be produced from the sub-collector. Today, the matter has been listed for fresh admissions. So I'll have to collect those records and produce before the Honorable Court. That is a separate issue, my lord.
So no problem.
But my lord,
I'm sorry,
No, it's not. We were thinking of a deprivation of a physical presence.
In fact, my lord, I reached little late. Let two issues. Number one, your lordship must have gone to the intent of this no confidence motion.
No difficult.
So I am aware the other day your lordship was also telling that if you don't enjoy the trust, then go and face it. The float test is the proper test. But the issue was basically before the learned single judge, whether it is an adjourned meeting or a deferred meeting.
It is a deferred meeting.
Absolutely, I bow down.
No difficulty. Only probably you were not there when
your lordship,
before the recess.
Kindly look at the impugned order then. Impugned order.
Before the recess, you were not there. So I must communicate what really passed through our mind. A judgment of this court is cited before us, where a distinction has been drawn between a deferment of a meeting and the adjournment of the meeting.
Justice,
no difficulty. And this has been there. It's a on the basis of this judgment, the definition of the adjournment is not satisfied. It is a clear case of a deferment. The embargo is of an adjournment. But if it is a deferred, then there must be some reason which must be shown for deferment. If the deferment is tainted with malice, then it strikes at the very root. Here, the reason was that we wanted to defer because 9 of the members, they have shown or they have communicated that they are because of their illness, they are unable to attend the meeting tomorrow.
Right.
Our condition, my view was that yes, there is no difficulty. One can defer. But there must be some tangible evidence which should come there. We asked him that these 9 people who have come and communicated, have they written a single letter? Have they communicated? How they have communicated? Just show us the document.
No, then it's fine. Then the case is over.
Over.
Yes.
Said over.
Your lordship is correct. Your lordship may kindly turn to page 60 of the brief, financial 4. It is, Lord, your lordship is, that's the correct thing.
Translation, that word is wrong. It
see.
is not postponement, it is keeping in abeyance.
अनुपस्थित रहिबा उक्त बैठकକୁ स्थगित। I was also looking at the lexical meaning in English to Odia. So even in some cases, I find the adjournment, let me just, suppose your lordship is in the midst of a hearing now. It's a court proceeding.
I gave an example.
That's correct. So it stands adjourned.
That the moment the court put a very difficult question to the member of the bar,
right,
in the midst of a hearing, he sought for an adjournment. Invariably, so we grant an adjournment.
Right.
So adjournment as is defined is that where the proceeding commenced. And in the midst of it, it is adjourned. No doubt.
Absolutely.
I told you, it's a clear case of deferment or kept in abeyance, as he says. The stagito means it is kept in abeyance.
Kept in abeyance.
Or postponed, I could say. Stagito means be a postponement.
Right.
Right. The correct word.
Once my Lord Chief Justice Mohta was here long back in 95, he used a terminology SO. We couldn't SO, stand over.
Oh.
In Bombay High Court, they used the expression SO. So initially, I also could not understand. Then I inquired from the bench clerk, what is that? A standover. So every court also they use. Suppose in the midst of house proceeding, legislative assembly. So that continues. For some reason, there is a ruckus or any disturbance. So that stands adjourned. So there is no dispute. I am grateful. So your lordship is on a question.
Deferment or a postponement, if it is tainted with a malice,
my lord,
and the malice strikes at the root of a decision-making process, if it can be reasonably inferred, then in that event, why not the court will intervene? That is the first question I put.
Number one.
So they say that because of the 9 members having fallen ill, then this postponement was done. I said, yes, then even a 1 member who has fallen ill, the postponement can be done.
Right.
No difficulty.
Right.
Then I say, show us the document. We simply saying that 9 members have fallen ill will not do. We'll have to show that they have communicated by a way of a letter, by way of a WhatsApp communication.
That would be there. That is there. That must be there. That was not the issue. That was not the issue, your lordship. Issue was that once the meeting has been postponed, it can't be moved within that moratorium period unless that is over 1 year. So, the whole object of this petition, if your lordship would look at, one, let me just explain. He or she, the petitioner wants to avoid the motion. So in some pretext, suppose, my lord, what would happen? I am giving an extreme situation now. Suppose it is held that no, this deferment is back. Then what would happen? Should they be permitted to give a fresh requisition?
Yes.
Should they be permitted to give a fresh requisition?
Always.
Your lordship
Your
lordship may direct that.
That's all. I was saying
No, I'm grateful.
I'm saying so. That was the impression
I got your lordship.
There is no difficulty in taking out a fresh motion.
Let your lordship direct.
And 1 year moratorium will not come in view of that.
That's correct. Your lordship may clarify and dispose. I got your lordship's point. I bowed down.
That is what I was saying.
That's correct.
To your junior.
No issue, my lord, no difficulty. But a person who doesn't enjoy the support of the house, your lordship may make it clear. That's the essence of the democracy.
No doubt about it.
Bomaing is very clear. Protest is the test. Whatever you go and prove your majority. So the public good is to be ensured.
Absolutely.
Panchayat Samiti has to
no doubt about it.
I got your lordship's point.
I don't doubt about it. They have to go.
Thank you.
Yes, now 12 members and 27 members. What do you say? The Advocate General has already said. They are putting a lot of, the obstacles that we suggested. The moment
that unity
by Mr. Da, he says he has no doubt about it.
That is clear. That's what 2 judgments are there. One Valmiki Pradhan has said
can say, but not the additional government.
No, it is not.
Why not?
That is the position.
Why not? Sir?
No, everybody can say it's not my prerogative.
No, they can definitely.
Since this is a question of interpretation, my lord, I came. I didn't know this part of the controversy.
Yes.
I thought that this adjournment would be.
No.
No, I'm so grateful. A date may be given so that it can be given, notice can be.
You can.
They have to give a fresh
You can make
requisition.
a fresh requisition.
Lordship is there.
There is no bar.
Same thing. 1/3 is the minimum now.
Minimum. How many petitioners are there?
22. 22.
The 22.
Including the chairman. Appellant number 4.
Persons, including the Sarpanch,
Chairperson.
chairperson of the Panchayat Samiti. File the instant writ petition. File the instant writ appeal. Sealing the order.
Page 62.
Order dated 6/5/2025. Passed in WPC number 10553 of 2025. Whereunder the said writ petition was dismissed, being unmeritorious. Undeniably, undeniably more than 1/3 members of the said Panchayat Samiti made a requisition flagging an issue of no confidence against the chairperson. And a date was fixed for convening the meeting. What is the designation of the officer?
Sub-collector.
Sub-divisional officer.
Sub-collector. Sub-collector.
Sub-collector.
By sub-collector. A day before the date fixed for convening the meeting, the communication was made by the said officer that the same is postponed for non-availability of 9 members who are indisposed. Challenging the same, the writ petition was filed, and a plea was taken that they said letter postponing the date for convening the meeting is illegal and to be declared as such. And in view of the provisions contained in section 46 capital B within bracket 2 within bracket G and 46 capital B within bracket 3 of the Odisha Panchayat Samiti Act 1959, such postponement be declared as annulled and an embargo created therein should remain binding on the parties. The single bench Proceeded on the premise that the postponement of a meeting is not akin to adjournment thereof, and therefore the embargo created under section 14 capital B of the said Act is not attracted. The single bench further held that there is no fetter on the part of the officer to postpone the date of convening for convening a meeting, and once the same is postponed on a justiciable ground, comma, it does not create any bar in fixing another date for convening the meeting. Stop. The entire dispute revolves around the interpretation of section 47 capital B of the said Act, which runs thus. On a meaningful reading of the said provisions, it is manifestly clear that a meeting can be convened on the requisition of 1/3 member of the Samiti, and the resolution so passed is supported by 2/3 of the total number of the members having a right to vote, comma, such resolution would invite an immediate vacation of office by the chairman or the vice chairman, as the case may be. Subsection 2 of section 46 capital B contained an exhaustive provision relating to the procedures and the manner in which such meeting is to be convened, and in the event the meeting is adjourned and a complete bar is created in adjournment of the meeting to a subsequent date. The consequence though not expressly provided therein, but in the event the resolution is passed, the resolution taken in the said meeting falls short of 2/3 members, comma, the resolution of such nature cannot be taken out before the expiry of 1 year from the date of such meeting. There appears to be a dissent in the mind of the petitioner and as well as the contesting respondents on the proper interpretation to be assigned to the words, the adjournment appearing in the said section. Stop. According to the petitioner, any deferment or postponement of the date fixed for convening the meeting would come within the ambit of an adjournment, and therefore the bar created thereunder would automatically be pressed in action, semicolon. On the other hand, on the other hand, the opposite parties have interpreted the same in a diametrically opposite manner and sought to make a distinction between a deferment and the adjournment, which cannot be treated as synonyms. Our attention is drawn to the division bench judgment of this court rendered in case of Sri Valmiki Pradhan versus State of Odisha and others, reported in 2007, 103 CLT 164. Wherein the coordinate bench has put emphasis on the word adjourned and deferred being the words of different connotations and applies in a different field. It is held that the adjournment has to be understood in the perspective of the fact where the meeting commenced, but for some reason or other could not be successfully concluded. On the other hand, the deferment though invites the fixation of another date, yet it stands on a different footing where the meeting never commences and the next date is fixed. By taking a conscious decision. It would be apt to recapitulate the excerpts from the said judgment, where such a distinction has been succinctly jotted down in the following manner. Paragraph 8, 9, 10. of the sit judgment court. Though both the words deferment and the adjournment are intended to achieve the common goal, that is, fixation of another date, yet it operates in an specified field. The deferment or postponement are always construed as prolongation of the thing which remain in existence before it could commence, whereas the adjournment, though also achieve the same goal, that is the prolongation of a thing to another date, yet its operations is restricted after the commencement of a thing and not before it. Such distinction is real, and no attempt should be made to blur the same. We are conscious that the words or the expressions used in a statutory document should be assigned the meaning which would further the object and the purpose underlying the incorporation thereof. And if a definite meaning is assigned in the statute itself, no external aid should be resorted to. I will stop there, please. Equally, the moment the statute used a word of a definite meaning, the interpretative tool should be taken recourse to further the object and not to frustrate the same. The complete embargo is created on an adjournment. And in view of a distinct meaning having assigned, as aforesaid, it can neither be treated as synonym of deferment or postponement, nor the same meaning to be ascribed as it would offend the core fabric of the legislative intendment. Oh, stop. We do not find any distinguishing feature nor any material is forthcoming to take a dissenting view to what has already been taken by the coordinate bench in an above referred report. Stop. The Committee of Judicial, in the event the coordinate bench could not persuade itself to the proposition of law laid down by an earlier coordinate bench, the proper course is to refer the matter to the Chief Justice to constitute a larger bench. Stop. The adherence of the judicial decisions taken by the coordinate bench is always regarded as binding on the subsequent coordinate bench, and the departure is departure is permissible on a sound legal reasonings to be provided by the subsequent coordinate bench while referring the matter to the Chief Justice to be decided by a larger bench. We do not intend to go further in this aspect, as we find that the action of the authority, though not coming within strictly within the folds of this aforementioned section, yet the doctrine of malice or action tainted with malafide motive are some of the concomitant of the judicial parlance, and the action of the authorities can be impinged to stop. Even if the requisition was made by the members constituting the quorum provided in the statute, the same is for the purpose of convening a meeting. And as the learned Advocate General fairly pointed out, it must pass the muster of flaw test on the date when the meeting is scheduled to be convened. The requisition is only for the purpose of bringing in notice to the authorities, the intention of no confidence on the chairman or a vice chairman, but in a meeting to be convened is strictly keeping adherence of the statutory provision, must take a resolution uniformly adopted by 2/3 majority of the members having right to vote. It is inconceivable that in absence of any convincing materials forthcoming before the court, forthcoming, the meeting was postponed as 9 members of the Panchayat Samiti were indisposed, which has been communicated. Oh, stop. There is no material forthcoming in support of the aforesaid contention, except the notice of postponement records such fact.
Because counter was not filed, it was disposed of, so it could not have been brought.
Stop. The postponement and or deferment solely on such ground without any corroborative materials is susceptible for ramification and may at times convey the latent intent which may not be made patent. Stop. At times, the resolution may fail because of the inadequacy in the numbers and sometimes it may pass depending upon the intention and the wisdom of the members on the day of the meeting. Since the deferment was made, deferment/postponement was made on the ground that the nine members of the Samiti were indisposed and could not attend the meeting. And in absence of any sufficient materials forthcoming in this regard, the possibility of a malafide hidden motive cannot be ruled out at this stage. Any action of the authority must pass through a muster of fairness, transparency, and impartiality. And any such action tainted with ill motive or malafide intendment, the same is susceptible to be interfered in the exercise of the powers conferred upon the court under Article 226 of the Constitution. Though the petitioner is very much vocal in his submission that the postponement was made with an intent to avoid the defeat of the motion, but we do not feel to go into the above aspect in absence of any cogent materials forthcoming in this regard. Since we find that in absence of any material, the postponement appears to be tainted with a malafide, we therefore find that even if the case do not come is strictly within the contour of the provisions contained in Section 46B of the Act, yet it needs interference on the reasons as expressed herein above. The notice dated 4/4/2025 is hereby caused and set aside. The order of the single bench is also set aside. However, there is no fetter. However, we made it clear that there is no fetter on the part of the requisitionist to make a fresh requisition, as the embargo of 1 year is not attracted in the instant case, and in the event such requisition is made, is strictly in adherence of the provisions of the statute, there would be no fetter on the part of the competent authority to act as permissible in law.
For the purpose of no confidence motion.
I say requisition.
At times the type of interpretation, my lord, I am really grateful. It will be a leading authority now. But one thing, your lordship, one line subject to your lordships, that the essence of this section is motive behind this legislative intent. I mean, the floor test.
That is what I have. I complimented you that fairly said.
That's correct.
Fairly said.
So therefore, my lord, a plethora of judgments are also there. Your lordship is
has to be. That's why I'm saying it has to be.
So your lordship may refer at least to one judgment. The whole this, my lord, in a democracy, this is the provision.
Sir, I can give lot of
I know, my lord.
findings
So
on that.
It would be an authority, my lord, for the posterity.
May I humbly pray, my lord,
In legal proposition, your lordship may incorporate.
may I humbly
Has already been
You want a garnishing of
my lord, item number 45
would be an
interim order.
garnishing. Don't go.
My lord, interim orders in item number 45 is continuing today, till date, my lord, today. So let's may extend it. Other side, Mr. Doctor was there, my lord. He is there.
I'm appearing for the crime, the opposite party in this case. This will
So let it extend. We are keeping it immediately after the
all other matters. Milan, one second. On the you clarify that on receipt of the valid requisition, the authorities are free to proceed with it.
So
Please.
it will not. I said it will not put any hindrances in making a fresh requisition.
Let deeply apply.
I have already said.
Fair enough.
And we have said the authority will act in accordance with law. No problem.
Fair enough.
No bar of 1 year will be extracted. What more? I have said.
Since the court is going to close, item 46 will grant us liberty to move before the vacation.
It's vacation.
Liberty.
Liberty.
Deeply applied.